Good morning, everyone. My name is Michael Kaelin, as Dave just said, and I'm a principal in the litigation group of Cummings and Lockwood, but I work very closely with the partners in the private clients group. For the last 25 years, I've worked mostly on trust and estates disputes, mostly representing clients in court in trust and estates disputes. You may be wondering as you're sitting there then, why should I be listening to him? Because the last thing that I want to do is be involved in a trust and estates dispute. The last thing I want to do is have to go to court. And so the reason I will give you for listening to me today is so you can avoid having to come work with me and you can avoid having to come work to court. The reason for you doing this is not just to avoid going to court, but more importantly, it really gets to the heart of what you do on a daily basis, which is you assist clients in their financial planning both before and after death. And one of the best things that you can do for your clients is to ensure after they pass away that the plan that they've spent so much time working with you on gets executed. And the reason that's a concern and you need to pay attention to it is because we've seen a tremendous increase in the amount of will contests, and now it's even before the person passes away, we're now even seeing an uptick in conservatorship matters where people are fighting over control of who's going to manage the client's assets even before they pass away. So what are the causes of this? The first cause I have listed here, I suspect if I asked the question to all of you, you would have had the answer for it. Because this phenomena of the children from the first marriage fighting with the spouse from the second marriage is so prevalent. It's almost automatic in that happening. But I want to jump to the last bullet point because this is really what's at the root of all this, which is that medical science has done wonders in enabling all of us to physically live longer. But what it hasn't quite kept up with is the ability to keep our minds fresh and agile and on top of things. And in a lot of instances, our bodies are literally outliving our minds in this thing. And then this comes together with the other factors that I've listed here, but particularly with whoever the caretaker is, who's ever the person living with your clients near the time of their death in the last few years of their life, they're going to be the person that your client is dependent on and has the closest relationship with, and it creates the opportunity for exploitation. When I use the word exploitation, I just want to alert you to another consequence of the circumstances I'm describing, is that there's also a tremendous uptick in elder abuse. And when I say elder abuse, I don't necessarily mean physical abuse. In fact, what's occurring with greater frequency is financial exploitation of people in the later years of their life. You people as financial planners are really on the front line of protecting your clients, so you should be mindful of that. So what about the rest of my presentation today? I will confess that the slides that I put together for this were originally from a presentation that I gave to lawyers on how to conduct a will contest. And so at first they may seem inapplicable to your situation, but hopefully I can persuade you they're very applicable to your situation, because going back to the point I mentioned in the beginning is the best way to avoid a will contest is to be prepared to win a will contest. And all of you sitting here this morning can really be the keys to winning a will contest. On this slide, the next slide, where I list the keys as first and foremost good witnesses, you could just strike out the word attorneys in the next line and insert financial planners. And the reason you can do that is because ultimately what is going to win the will contest is the witnesses. Who's testifying live in court? And obviously, your client is not able to testify in court. So the best witness is going to be the person who has the most knowledge of what your client's testamentary plan was, what your client's financial plans were. And in most instances, that will be the person's lawyer who did their estate planning, or it could be you. So to prepare yourself for doing this, the next thing you need to know is that in addition to being able to testify in person yourself in court, to help yourself testify in person in court, you're going to need a good paper trail. And when I say a good paper trail, it's just really basic documentary information. It's having a record of when you met with your client, what was discussed with your client, what did your client tell you they wanted to do, and why did they tell you they wanted to do that? And just as a practical matter, you also have to look ahead. While all of this may be fresh in your mind when you're meeting with the client, very little of it is going to be fresh in your mind years later when your client passes on and someone's contesting the will. The next slide I have just to emphasize this point about how important the witnesses are. One of the first questions people ask who have never really been involved in a will contest before, is it a good idea, if there's any question about the client's capacity, to videotape the execution of the testamentary documents? And the answer to me is obvious, that if you're asking me if it's a good idea, you have enough questions about the client's capacity that you're thinking about videotaping the deposition, you probably shouldn't do it. And the best example I could give you to show you how this can really work against you is I was involved in a will contest where the situation I just described was present. The lawyers involved in the case videotaped the deposition. They actually had the litigators videotaping the deposition instead of the trust and estates lawyers, although the trust and estates lawyers are present. And they went through this series of questions to try to demonstrate that the person had the mental capacity to execute a will at the time, asking them where they were. They were in the lawyer's office, where they lived, the town they lived in, where they had lived previously, who their children were, who their grandchildren were. The lawyers who videotaped this were really proud of this when they came to probate court to demonstrate to the probate judge that the person knew what they were doing when they executed the will. And I was representing one of the daughters who was contesting the will that benefited her brother. And right after the video, she just got on the witness stand and explained that those places my mother said she lived, she never lived in. And the number of grandchildren she gave, she said 4, she has 6. And so she just went through. And the lawyers who videotaped this were just clueless because they just didn't have the background. To put this now more in the legal context, so you get a better appreciation for where you fit into this. If you look at the legal grounds for a will contest, and this is not a typo, I put the undue influence in 4 times for emphasis because that's the only kind of will contest I've ever been involved in. The first thing people that just read books about this think of is whether the person had the capacity to execute the will. Well, many of you probably know the capacity to execute a will is just that you know what you're doing when you do it. It's a moment in time. It's not difficult, even when people have declining mental abilities. There's always periods of lucidity. There's always periods when they know what they're doing. And at the moment of time they execute the will, normally the only people present are the lawyers, and the lawyers are going to testify they had the capacity, and who's ever challenging the will is not going to have any witness to rebut that. So dismiss this idea that like lack of capacity really matters. And the idea of fraud too. Fraud, what lawyers think about as fraud is that, that somebody's tricked into it, that somebody made a misrepresentation to induce them to do something they really didn't want to do. And that doesn't really happen in the real world either, or at least it just merges together with undue influence. So what is the legal standard for undue influence? This idea of undue influence is really an amorphous concept, but what it reduces to is, was this will a knowing and voluntary act on the part of the testator? Meaning that another way of phrasing this is that, does the will reflect what the person would do if they were not subject to undue influence? Again, I'll just keep going back to this point. That's where you come in on this thing, because the way that you win a will contest is not showing that the person knew at the moment of time that they executed the will, that they knew what they're doing. The key to winning the will contest is demonstrating this will was the product of thoughtful, considered planning over a significant period of time. And when I say a significant period of time, it could even be, 3 or 4 months. But the will contests you win are the ones where you have the documentary evidence that said they met with the lawyer, they met with the financial planner 3 months ago. They told the financial planner, they told the lawyer, this is what they wanted to do with their assets when they passed away. And then the financial planner or the lawyer makes a note of that. They make a note, we had a meeting at that point. They write down what the client's objectives were at that time. Then there's a referral to a lawyer if they need to get the documents done. Then the lawyer meets with the client. The lawyer does drafts of the documents. Drafts are sent back and forth. There's written communication back and forth to confirm that the drafts of the will reflect what the client's true intentions are. And then by the time you get to the actual will signing, it's a non-event, because you're able to demonstrate that this is what your client truly wanted to do and truly intended. Just to show you what can happen when things go wrong, I happened to notice this morning this case of Dinan v. Marchand. What you see on the screen is a Connecticut Supreme Court decision from the year 2006. And what you should be shocked to find out, and there's no exaggeration or embellishment here, this case is still going on. What's more shocking about this case is that the testator passed away in the year 2000. By the way, it's a fight between the second spouse and the daughter from the first marriage. Second spouse, who married the testator, I think 2 years before he died. He was in his 80s, she was in her 70s. She's now in her 90s, and it's still going on. Just to give you a sense of what a disaster it is if you don't do the planning necessary to avoid a will contest. And they didn't in this case. He did everything wrong in this case. The will was changed at the last minute. But the way the court system works is, so he dies in the year 2000. They actually have a jury trial in the year 2004. The jury finds there's no undue influence. The second wife appeals. It goes to the appellate court in Connecticut in 2005. They affirm a judgment of the jury. It goes to the Connecticut Supreme Court. 2006, they decide that they affirm the jury's verdict. They find there's no undue influence. And so why is it still going on? Because once it was determined that this was the will, one of the things that was wrong with the will, because they didn't have proper estate planning lawyers put this together, is they made no provision for the surviving spouse in it. They made no provision for the surviving spouse because the testator himself was a lawyer. He was getting on in years, and he wanted to prove to his daughter that he wasn't marrying this woman so late in life, that she wasn't marrying him for his money. and he was going to prove she wasn't marrying him for his money by excluding her from the will. Unfortunately, the second wife herself was a lawyer and knew she couldn't be excluded from the will. So once the will contest was resolved in 2006, she then started an action to get her statutory share. And that's what's been going on ever since in accountings and everything else. So I say all this, number one, to keep you interested in this presentation, but more importantly, so that you do the things that you can and should do to help your client avoid getting in situations like this. The breakdown of the 4 elements of undue influence are, you have a person subject to undue influence. So what does that mean? This means that the person's ability to make decisions for themselves is impaired to some degree. Impaired to some degree, usually because of a mental or physical infirmity, that they have some health issue. It doesn't have to be exclusively a mental impairment. You know, people that are dying from cancer are in a weakened state. They're dependent on other people. They're subject to being unduly influenced by somebody. Number 2, an opportunity to exert undue influence. What that usually refers to is isolating the testator from other family members, from other friends, from their financial planners. It's somebody alone with the person. And so you can see how this evolves. You have somebody who's dependent because of a mental or physical infirmity, someone else to provide for their basic needs. And if there's only one person doing that, that person has the opportunity to really control what the testator's doing it. All right, so disposition to exert undue influence is just, you look for circumstances that look like the undue influencer is doing things for their own personal benefit rather than the benefit of the testator. So what I was showing you previously was the way lawyers and judges and courts express this. The undue influence factors I've listed on the next slide are the way that lay people describe what's going on. The biggest factor, and then this gets back into the point about your planning and where you come into this, is late and unexplained changes in testamentary dispositions. The will contests that succeed and the will contests that are almost always brought is when you have someone with severely diminished capacity who is isolated and alone with one person, and then their will or other testamentary dispositions are changed at the last minute to benefit that person. The last point there is just fits into the rest of what I was saying. But since I'm on this point about sudden and unexplained changes in testamentary dispositions, I can also make the point about having sympathetic witnesses and fit it into the larger point, which is if you want to win a will contest, you want to avoid a will contest, you have to understand why the person is making the changes to their will or other testamentary instrument at the time that they're making those changes. If you think back on some of these undue influence factors that I just ran through, I had a case one time where every single one of these factors was present. That there was, the testator was dying of lung cancer, he was living with his second wife, she had exclusive control over him, her lawyer drafted the will was changed not just to exclude his 2 daughters, but to exclude his grandchildren. Exclude everyone and give everything to the second wife. And when the client first came to me, and I was representing the daughters in this case, I thought this was a slam dunk, that we were going to win the case. And then the one thing that is certain about every single trial any of you are going to be involved in, every trial I've been involved in, is you're going to be surprised by something. And in this case, we got in all our evidence of everything that second spouse had done to really control the disposition of the will, make everything for her favor. And then in rebuttal to us, she testified how 6 weeks before he died, he was going from Florida to Connecticut. And at that point, he was really literally on his last legs. To fly from Florida to Connecticut to New York, he had to have oxygen. He had to be in a special seating arrangement. He had to have like a nurse with them. And more importantly for this case, he had his second wife with them. And she described the ordeal of getting him on the plane and how awful the flight was and how he was getting sick in the flight. And how the only thing she asked his two daughters to do when he arrived at the airport was to pick him up and to take him from there to get him to his home so he can rest in peace for the last few weeks of his life. And what did the daughters do? They sent a car to get him. And as soon as she described how awful this flight was, she described everything that she did, and then she described what the daughters did, I just put my pen down. I looked at the jury and I was like, we lose. It was like, and we did. If you are involved in a will contest or you're trying to think of ways that, we avoid getting involved in a will contest, there's just such basic questions that you need to ask, like, who prepared the will? When was the will prepared? Why was the will prepared? What changes were made from prior testamentary dispositions? Who initiated the changes? Who was present when the changes were discussed? Where was the will executed? What was the testator's mental and physical condition when the will was executed? It's almost like common sense. If you want to avoid a will contest, you spend time with your clients. You understand what they want to do and why they want to do it, and you make notes about it. And then chances are, when they get to their end of their life, no one's going to be able to challenge that. And if they do, you can be a good witness for them by getting on the witness stand and telling the judge or jury forthrightly, this is my client. This is what my client wanted to do. I've known this client for 20 years, and this is why they wanted to do it. And they will prevail. Thank you.